Good afternoon. I'm Eric Tuchmann, Senior Vice President, General Counsel, and Corporate Secretary at the American Arbitration Association and our international division, the International Center for Dispute Resolution. I'm joining you from Singapore at our Asia Case Management Center, and this is where we administer all of our cases involving a party from Asia, including China. I wish I could be with all of you today, and I've enjoyed my time joining prior arbitration summits in previous years, and I hope that before too long we'll be together again in person as well. During this discussion, we are focusing on an important topic: how all of us in the field of international arbitration can work towards ensuring efficiency and speed in the arbitration process without compromising justice and fairness. This is an enduring question, but it's an important one to revisit time and time again, particularly in the current environment with all the changes that have taken place with respect to how international arbitrations are carried out and conducted as a result of COVID. First, an important step in addressing justice and fairness is by increasing transparency. Transparency in the process. As an institution, we think about this with great frequency. How can we allow parties to better understand how we as an institution make decisions, how we advise arbitrators on issues of ethics and the like. And we consider these issues with great care during our recent amendments of our international arbitration rules. The process of amending a set of rules is something that's not done lightly. Great care is taken into consideration. We've got to ensure that the rules and the amendments that they contain are universally accepted, no matter where in the world they might be used, and no matter where in the world there might be an enforcement proceeding or a proceeding to challenge an award or any other court-related matter that connects the arbitration. And in fact, our committee, our Rule Amendment Drafting Committee, was represented by an individual from China. We feel as though that was an important addition to our group. They were quite active. Also had individuals from Europe, from other parts of Asia, Latin America, and the United States. So they truly are an international set of rules and continue to maintain that character. We think the most innovative amendment that's contained in our rules, and it's an important one with regard to the efficiency of the arbitration process, is actually contained in Article 6, titled Mediation. And it provides that, subject to any agreement of the parties otherwise, or the right of any party to elect not to participate in the mediation, the parties shall mediate their dispute pursuant to the ICDR's international mediation rules concurrently with the arbitration. So there's some important parts of this very brief rule. One is it now contains a presumption that the parties are going to mediate their dispute at some point during the arbitration process. That is something that is new and unique to any set of international arbitration rules. There are important caveats. Any party can unilaterally decide that they don't want to mediate. And the mediation will take place concurrently with the arbitration. That is another presumption contained within this rule. In other words, a party that might want to mediate but's concerned about a month-long or many month-long delay that can be associated with mediation does not have to worry about that taking place under the rules drafted. The mediation will concur while the parties are perhaps considering their arbitrator appointment, proceeding with hearings. It can be at any point during the arbitration process. We think that the incorporation of a mediation rule in a set of arbitration rules is an important step in increasing the use of mediation, which, when utilized, is quite successful in resolving disputes, and also helping parties gain a greater appreciation for the process. Article 14 of the International Arbitration Rules now impose additional obligations on arbitrators. Those obligations include the need to maintain the standards of impartiality and independence that have become widely accepted, as appropriate in international arbitrations, to know and act in accordance with ICDR rules and the terms of the notice of appointment provided by the ICDR, and to act in accordance with the Code of Ethics for arbitrators in commercial disputes. The Code of Ethics for arbitrators has been widely recognized and have been applicable to arbitrations administered by the AAA-ICDR for many years. But what's new in the most recent amendments is explicit reference to the Code of Ethics in the rules themselves to make clear of their applicability and to provide transparency about the standards that arbitrators are expected to hold themselves up to. A related issue to arbitrator disclosure and independence of the arbitrator actually exists in a new addition in the rules that relates to third-party funding, also addressed in Article 14. And it provides that on the application of a party or on its own initiative, after consulting with the parties, a tribunal can require the parties to disclose whether a non-party, a third-party funder, or perhaps an insurer, has undertaken to pay or to contribute to the cost of the arbitration, and to identify the person or entity concerned, and to describe the nature of the undertaking. The purpose of this rule is only to address potential conflicts that might arise with an arbitrator and a third-party funder of some type that would otherwise be unknown to the parties and even to the arbitrator, perhaps. So, where an arbitrator or their firm may have an ongoing relationship with a third-party funder, it may be appropriate for conflicts purposes for that information to come out. The ICDR's approach, however, has been to allow a case-by-case analysis by the tribunal as to whether that disclosure is necessary. Another rule that specifically addresses the efficiency and economy in arbitration addresses the early disposition of issues, and by providing guidance to arbitrators and parties on the standards that must be met when such an application is being submitted. A party seeking early disposition of an issue must first request leave to file an application, and only after determining that the application has a reasonable possibility of succeeding, that's the standard, a reasonable possibility of succeeding, that it will dispose of or narrow one or more issues in a case, and that consideration of the application is likely to be more efficient or economical than leaving the issue to be turned on the merits, the tribunal may allow the application to be filed. This will address what some parties complain about as the needless submission of applications for the early dismissal of a case or of a claim in matters where it simply isn't warranted. It goes without saying that the use of video, audio, and other electronic means for conducting preliminary matters and final hearings has become essential to the arbitration process. That's how we've all accommodated, and frankly, how international arbitration has prospered and shown its potential during the pandemic. Incredible flexibility, the ability to change on short notice the manner in which an arbitration would proceed. That's all taken place, and we still see that happening today. But we did want to make sure that our rules also were specific with regard to the use of video, audio, and other electronic means for conducting preliminary matters and final hearings after consultation with the parties. Finally, there's a huge interest and demand in arbitration awards. Parties, practitioners, academics, and also policymakers want arbitration awards to better understand how the process works, the types of issues that are being decided, and how parties, large or small, regardless of their character, might be impacted. We've made an incremental step towards the publication of additional awards because we feel there is some value where the parties consent to having a larger number of awards being made available. Accordingly, Rule 40 now provides that unless a party has objected in writing to the publication within 6 months of an award being issued, that the AAA is permitted to publish awards, orders, decisions, and rulings, although edited to conceal and redact the names of the parties and other identifying information, to allow for the publication of awards in those matters. That provides a summary of some of the most important changes that we've incorporated into our arbitration process and into the rules as they relate to the specific issues of economy, speed, justice, and due process. These changes are ones that, again, have been given significant consideration and have been very widely accepted with some significant approval, we're happy to say, among parties. And with that, I end our discussion today. Again, I hope we are able to see you soon. All of us at the International Center for Dispute Resolution send you our very best and wish you well for your program today.